Breaking news, the H-1B just got a $100,000 price tag, but only for some applicants. Here's what you need to know before you panic. I'm Mohammed Amir. I'm an immigration attorney and founder of Amir Law Firm. Today, we are breaking down a brand new presidential proclamation that dramatically alters the H-1B process for workers abroad. Before I start, let me remind you that this channel is dedicated to provide you with immigration news updates and information. Make sure to subscribe to our channel. Also, hit the bell icon so you can be notified as soon as a new video is posted. Let's cut through the noise and focus on what this means for you. This proclamation takes effect on September 21st, 2025 and will last 12 months, unless extended. This new presidential proclamation imposes an additional fee of $100,000 on any employer filing an H-1B petition for a foreign worker who is outside the U.S. Without this payment, entry will be denied. Now let's discuss what is the scope of restrictions under this proclamation. The proclamation repeatedly uses the word entry into the United States. Section 1A of proclamation restricts the entry into the United States of aliens as non-immigrants in H-1B status, unless the petition is accompanied by a $100,000 payment. Section 1B directs the Department of Homeland Security to restrict decisions on petitions for H-1B specialty occupation workers who are currently outside of the United States. With the limited available information, this makes it clear that the fee applies only to H-1B petition files for individuals outside the United States seeking entry. However, it's subject to change as the details unfold. Now, the bright side, at least for now, who is not affected? Applicants with change of status, extension of U.S. The proclamation does not cover change of status from another status to H-1B inside the U.S., nor extensions of status for those already in H-1B. Change of status and extension do not involve a new entry in the United States. They are adjudicated domestically. Therefore, a $100,000 fee does not appear to apply to change of status or extensions. Also, existing H-1B holder abroad appears to be safe as well. If someone already has an approved H-1B petition and a visa stamp and they are returning to the United States with the same petition, this proclamation appears not to impose a retroactive fee. However, if a new petition is filed while they are abroad and the petition leads to a consular processing visa issues, the $100,000 would apply. What are the exceptions to this new rule? Proclamation allows the Secretary of Homeland Security to exempt an individual, alien, company, or even an industry if it's in the national interest and does not pose a threat. This is a discretionary, means that DHS has full control to define the scope of exemption. Now on the compliance side, employer must document and retain proof of payment. State Department and Department of Homeland Security will verify before granting visa. In summary, this rule appears to create a two-tier H-1B system, affordable filing for those already in the U.S. and prohibitively expensive filing for new hires abroad. Words for employers. If your candidate is in the U.S., file now. If abroad, consider alternatives or wait for further Department of Homeland Security guidance or exemptions. $100,000 won't apply to everyone, but if you don't know the difference, it could cost you your visa. Stay informed, stay protected, and if you need guidance, call us at 212-372-4878. Thanks for watching, and I will see you in my next video.